MARBURY v. Madison, 1803. This case set a precedent in what is today known as judicial review and gave the American courts the power to strike down laws that contradict the Constitution, and it also makes clear that courts in the United States, especially the Supreme Court, has the sole power to define the Constitution itself. William Marbury, a prominent businessman from Maryland, brought the case to the Supreme Court against the Secretary of State James Madison and requested the court issue a writ of mandamus, a sort of court order compelling Secretary of State Madison to deliver Mr. Marbury's commission for justice of peace position. To understand the case, we need to talk about 1800's presidential election in which incumbent President John Adams, seeking his second term, was being challenged by his vice president Thomas Jefferson. Adams was aligned with the pro-business and big government advocates of Alexander Hamilton's Federalist Party, and Jefferson was advocating for a small unlimited federal government. And after a long election, Thomas Jefferson was elected President of the United States, and he took office on March 4th, 1801. 2 days before he vacated the office, President Adams appointed 60 Federalist supporters to circuit court judgeships in which Congress had created in the Judiciary Act of 1789 and Justice of Peace positions. And on March 3rd, the Senate confirmed these nominees, and their commissions were signed by President Adams. The commissions were sealed by Secretary of State John Marshall, who President Adams had also appointed to serve as Chief Justice to the Supreme Court. Next day, March 4th, Thomas Jefferson was sworn in as President of the United States, and as soon as he took office, he ordered his Secretary of State James Madison to stop the delivery of the commissions and declared them void. One of those commissions not delivered was issued to William Marbury, and over the next couple of months, Marbury would continually ask Madison to deliver his commission, and Madison would refuse. And on December 1801, Marbury would file a case against Madison to the Supreme Court and request the court to issue a writ of mandamus ordering Madison to deliver Marbury's commission, and the case was presided over by Chief Justice John Marshall. Marshall wrote the court's opinion and structured it around 3 questions, which in turn he answered. First question: did Marbury had a right to his commission? Marshall answered yes. The commission had been properly signed and sealed, and the delivery of the commission was merely a custom, not an essential element of the commission itself. He quoted, "The President's signature is a warrant for affixing the Great Seal to the Commission, and the Great Seal is only to be affixed to an instrument which is complete. The transmission of the Commission is a practice directed by convenience, but not by law. It cannot therefore be necessary to constitute the appointment which must precede it and which is the mere..." This brought Marshall to the second question. If Marbury had a right to his commission, was there a legal remedy for him to obtain it? Marshall answered yes. Marshall wrote, "It is a general and indisputable rule that where there is a legal right, there is also a legal remedy by suit or action at law whenever that right is invaded. This rule derives from the traditional Roman legal, where there is a legal right, there is a legal remedy." Marshall quoted, "The very essence of civil liberty consists in the right of every individual to claim the protection of the laws whenever he receives an injury." Then Marshall came to the third and most important question. If there was such a legal remedy, could the Supreme Court legally issue it? Marshall said, "The issue depended entirely on how the court interpreted the text of the Judiciary Act of 1789, in which Congress had passed to establish the American federal court systems, since the U.S. Constitution itself only mandates the Supreme Court and leaves the rest to the Congress to create." He quoted the Section 13 of the Judiciary Act of 1789, which said, "The Supreme Court shall have original jurisdiction over all cases of civil nature where a state is a party, and shall have exclusively all jurisdiction of suits or proceedings against ambassadors or other public ministers, and the trial of issues in fact shall be by jury. The Supreme Court shall also have appellate jurisdiction from the circuit courts and courts of the several states in the cases herein after specially provided for, and shall have power to issue writs of mandamus in cases warranted by the principles and usages of law to any courts appointed or persons holding office under the authority of the United States. Marshall explained in the opinion, under original jurisdiction, a court has the power to be the first to hear and decide a case, and under appellate jurisdiction, a court has the power to hear a party's appeal from a lower court's decision and to revise and correct the previous decision. Marbury had argued that the language of Section 13 of the Judiciary Act gave the Supreme Court the authority to issue writs of mandamus when hearing a cases under original jurisdiction, not just appellate jurisdiction. Marshall agreed with Marbury and interpreted Section 13 of the Judiciary Act to authorize mandamus on original jurisdiction. But as Marshall then pointed out, this meant that the Judiciary Act clashes with Article 3 of the United States Constitution, which establishes the judicial branch of the U.S. government. Section 2 of Article 3 defines the nature of the Supreme Court's original and appellate jurisdiction. Quote, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as this section of the Constitution says. The Supreme Court only has original jurisdiction over cases where a U.S. state is a party to a lawsuit or where a lawsuit involves foreign dignitaries. In Marbury's case, neither of those categories covered his lawsuit, which was a dispute over a writ of mandamus for his Justice of the Peace Commission. So, according to the Constitution, the court could have only heard Marbury's case while exercising appellate jurisdiction, meaning as an appeal, not under original jurisdiction, meaning a lawsuit directly filed with the Supreme Court as Marbury had done. But, as per Marshall's earlier claim, Section 13 of the Judiciary Act of 1789 said that the Supreme Court did have original jurisdiction over mandamus cases like Marbury's. This meant that the Judiciary Act apparently took the initial scope of the Supreme Court's original jurisdiction as specified in the Constitution and expanded it to include cases involving writs of mandamus. Marshall ruled that Congress cannot increase the Supreme Court's original jurisdiction as it was set down in the Constitution, and therefore that the relevant portion of Section 13 of the Judiciary Act violated Article 3 of the Constitution. After ruling that it conflicted with the Constitution, Marshall struck down the relevant portion of the Judiciary Act in the U.S. Supreme Court's first ever declaration of the power of judicial review. Marshall ruled that the American federal courts have the power to refuse to give any effect to congressional legislation that is inconsistent with their interpretation of the Constitution. Marshall wrote, "It is emphatically the province and duty of the Judicial Department to say what the law is." Chief Justice Marshall killed two birds with one stone. First, by refusing to issue the writ of mandamus to Secretary of State James Madison, he protected the court's integrity, which could have been put in jeopardy, and him accused of being partisan by the Jefferson administration. Second, by striking down Section 13 of the Judiciary Act of 1789, Marshall set the precedent that the courts in the United States are to act as a check to the other two branches of the government. This case is still today being discussed in the realm of the constitutional law in the United States, and Chief Justice Marshall is praised for how brilliantly he argued the constitutional part of the case and setting this precedent of judicial review, which till today is used in the United States. Marshall is also criticized for not recusing himself from this case, since there was a lot of conflict of interest for him because of him being part of the earlier administration and having been at the forefront of the issue that raised this case. If you want to understand how Chief Justice Marshall argued the judicial review part, click on the pop-up of your screen. Don't forget to subscribe and hit the notification bell. If you like this video, give it a thumbs up and leave a comment down below. Thanks for watching. See you in the next video.